Hey, everybody, welcome to yet another great interview in our virtual business summit. And today we're going to be talking to Wayne Carrol from Inspired Ideas Solutions. And we're going to be learning everything we need to know about patents and trademarks and the like. What's involved, why do we do that as a company? So without further ado, Wayne, please tell us who you are, what you do, and a brief intro into what we're going to be talking about today.
All right. So I am a patent attorney. As far as attorneys go, you need to actually pass an additional bar exam to be a patent attorney. So I've passed that. I've been practicing for over 15 years and worked with a lot of companies. I've worked with big Fortune 500 companies, a lot of small companies, small businesses. So I've seen pretty much the whole gamut, and a little bit about intellectual property. So first of all, let me say that intellectual property is property. If you think of your house, that's your property, but the deed is what says you have exclusive rights to that property. And the same is true with intellectual property. So the property itself is an invention or a trademark or a recording of a song, or the music itself. Those are all intellectual property, and the things that protect them, that show that you have exclusive rights, are patents, trademarks, copyrights, and in some cases, trade secrets. So those are the rights that protect that valuable property.
Okay, cool. Now, let's kind of get into a little bit of like, what exactly is a patent? How does it work? And then we'll do the trademark second. What is a trademark and what does that do? Let's kind of define things a little bit.
All right. So with a patent, it covers, well, really there's two kinds of patents. And most people think of the utility patent that covers how something works. And usually that's, well, it doesn't have to be something you hold in your hand, but more and more, there needs to be something you can touch, whether it's a computer or a device. And we're going to have to explain it in that manner to get a patent. So it can be described as a process or a machine, a composition of matter. So those are the main categories for utility patent. So, for example, the process of making Coca-Cola could be patented, but it hasn't. It's been kept as a trade secret. And one of the reasons is patent means open. When you file a patent, you have to reveal how to make and use the invention. And it's not revealed at the end of your patent term, it's revealed at the beginning. And a patent lasts for 20 years from when you file the patent application. So the second kind of patent is a design patent. It covers the way something looks. Apple used the design patent as one of the many patents when they were in a big battle with Samsung, and it was the look of the face of an iPhone, and they were able to get internal documents from Samsung through the whole litigation process that showed that Samsung had actually been discussing, how do we get our phone to look like theirs? And that's what a design patent covers. Does it look like it's the same design? And it specifically does not cover functional aspects. So if you have a crank handle on something and you say, well, that's my design, maybe the look of the crank handle, but the fact that there is a crank handle isn't going to be a protectable design element. So that's kind of a quick overview of patents. Do you have any questions?
Yeah, let's talk about patents for a little bit. So we have the two kinds, the utility and the design. And we went over a few little examples of those kind of things. So let's kind of go a little bit more in depth because you touched on it a little bit at the end there of like, the crank handle thing not being potentially under that. Like, so what are some things that can be patented and what are like, and how would it sometimes not be? So you explained that if a crank handle was part of something, it might not necessarily be. So let's kind of clarify that a little bit.
Right. So, well, on the design patent side, um, a lot of times what applicants do is they will show part of the invention in dotted lines, um, to show that's just kind of the how it works, so that you understand what it is that their design applies to. Even if they don't do that, a competitor that makes a design, if the only thing they copy is functional, then they don't have the right to stop them from the patent holder doesn't have the right to stop them. And it is a fuzzy line, especially on the design side of, is it the same design or isn't it? So a really good example that's been in the courts is the Croc shoes. It's got those holes, and it's got that certain look, and that's they did a design patent, or for each slight different one, they did several design patents for the Croc. Somebody else made one, and they convinced the patent office that theirs was a different enough design. But then the company that has the Crocs design patent, they went back to the patent office and said, no, you got it wrong. And it went up to a court, and the court says, yeah, that's too close. It looks like a Croc. So it infringes on their design.
Mm-hmm.
So that's a really good example. Footwear has been around a long time, and the Croc's a little bit different, but in terms of a function, where the strap isn't probably different enough. And to get a patent, so some people think, oh, well, a patent's expired. Can I apply for it now? The answer is no. A patent, to get a patent, you need to have something that has not been published before. So if it's already been out there, and published means anything on the internet or anything that's, and even in other languages and in other countries, if it's publicly available, then it's not available for you to patent. The other thing is you actually have to be the inventor. So, if you go visit your friend and you see him do something, and you're like, hey, that's a great idea, I'm going to go patent that. You're not supposed to do that. You could lie about it, but then every time you lie, you have to cover the lie forever, and it becomes a mess.
It wouldn't work, yeah.
And so those are some of the requirements. The other challenge is it has to be not obvious. So you could say, well, this exact thing hasn't been done, but if it's considered an obvious step from what's been done before, then it's also not patentable. And that's one of those gray lines. And it's very common for us when we file a patent application to get a rejection where the patent examiner says, well, that looks obvious to me. And then we go through some arguments and say, no, we don't think it is, or, okay, we'll make the language slightly different. A utility patent, the legal rights are covered by a claim, which is a written out one sentence paragraph. And the way infringement works is, for someone to infringe, they have to do everything that is in that claim. If they leave one thing out, they're not an infringer. So utility patents, it's easier actually than design patents to tell, if it's a close case, if you clearly say, well, I don't do this one element, then you don't infringe. With the design patent, it's a question of, does it look like their design? And it's also compared to what's been done before. Mm-hmm. So design patents are much more like a trademark in terms of how they look at them, how they enforce them.
Okay.
And design patents last for 15 years. When we get into trademarks, they can last as long as you use them. So
Cool. All right. So I want to kind of spit some stuff back at you to make sure I understand.
yeah,
So it seems that like the design patent is harder to prove that someone's taking it or not taking it, or it can be at least. And I think that that seems to have to do more with an art side of things, like where like the croc, your example, they designed it, but it's not exactly like that's why it might have so much more interpretation. Whereas it seems the utility patent is more technical, more logical, more direct, if you will, in how it's formatted or designed, which is why there's less issue with determining whether someone's infringing or not. Is that correct, or am I just like?
yeah, and um, don't misunderstand that. So patent litigation, when it comes to utility patents, it often gets very expensive because when it comes down to specific words and trying to say, does this device have that element or not? It might sound like it's clear cut, but it's often not. Well, and the close cases are the ones that go to court.
Mm-hmm.
If it's not a close case, if it's really clear one way or the other, they're most likely going to settle, or they'll settle before it actually goes to a trial through the litigation process. But yeah, there's plenty of disputes. But what the dispute is about in a utility patent is, do they have each element? And when it's a physical product, it's going to be each physical element that's listed out. When it's a process, it's going to be each step of a process, and it might not have to be in order. It depends on how the claim is written.
Okay.
So
We talked about patents, what they are, and the two areas that they can be separated into. We gave some examples so people can kind of understand, how patents in general work. And I think that the next thing I wanted to break down was, my brain just farted. I'm going to take a second to remember the question. I'm going to edit this out. What was it? We were talking about, because I had thought about it, and then like I started talking about it, and that's when I forgot it.
yeah, design patents and
Yeah. What was it? We talked about how long they last. We talked about the pieces of them, utility. Something you mentioned in that last thing.
a good question is, what do you need in order to file a utility patent? Do you have to have it produced? Can it just be in the design stage, or do you have to show it working?
Yeah, I'll ask that next, and maybe that'll help me remember the thing.
Okay.
All right. So we talked about the two different kinds of patents and the different things that they, what they cover and how long they last. But I think the next thing to get into is, what can we cover with a utility patent? Where does it need to be in order to be patented? How early can we do it? Same thing with a design patent. So tell me at what stage we can file for those things, and how those things are done.
Right. So the invention process often has multiple iterations, but when you're fairly certain you're close, or you have all the major mechanical parts of an invention designed, it doesn't have to be produced. You need to be able to, with the help of attorneys and draftsmen, be able to describe it in words and drawings, how you would make and use it. So you don't have to have it built to patent it. And as I mentioned, if it's been published, then that can prevent you from getting a patent. And that can apply to you as well. So if you even publish it, it can prevent you from getting a patent. In the US, there's a 1-year grace period. So the 1 year from the date of that publication, is the last moment you can file a patent and not have your own publication be used against you. But in other countries, most other countries don't have that grace period. Well, none of them have it for a year. A few of them have it for 6 months, but the vast majority have no grace period. If there's any publication, even by you, a day before your filing date, you will be denied the patent if your publication shows what's in the patent. So it is a bit of a challenge of when do you file a patent, because you don't want to file too late. But if you're still developing and you think you might be changing something, sometimes it makes sense to file what's called a provisional application. And provisional means temporary. You don't have to start with this, but it doesn't get examined for patentability. It lasts 1 year and then expires. And it never becomes a patent. So you wonder, what good is it? So what good it is it allows you to claim a filing date. And when before the end of that 1 year, you file a non-provisional, which just means not temporary, patent application, and then you claim the filing date of the provisional. So you can give yourself that 1 year, or even just part of a year, to be checking on the... Sorry, did that dinging show up?
No, I didn't hear it.
Oh, okay. Let me back up a bit. So you can get that 1 year or a part of 1 year to continue to validate and prove that the invention is going to work. And it also, you might be doing market validation. There's a lot of validation you need to go through to make sure a new device is going to succeed in the market. So the provisional can give you that time, but it also does delay when you get the patent, because you file and they don't start examining. It doesn't get into the examination queue with a provisional application, but it also doesn't start your 20-year clock for your patent term. That starts with the non-provisional filing. So there's all kinds of strategies, and that's one of the things I make sure I do is I talk with clients about what is their strategy, what is their business plan, what do they see is going to happen with this patent, and how is it going to help their business. In some industries, that having it actually start a year later is really good, like pharmaceuticals. If you've got a blockbuster drug, the last year is way more valuable than the first year. So they would much rather have a year at the end than at the beginning. A lot of other industries, they think, things are probably going to be moved on after 10 years. So it's all about, what's the strategy that's going to work for you?
Absolutely. All right, cool. So we talked about patents and kind of dived into a lot there. So let's switch on to trademarks. What does that entail? Give us the definition and kind of what gets covered with trademarks.
Okay. A trademark is a symbol or words. It can even be sounds or a color. But most of the time people think of either a logo, which is a symbol, or words as a trademark. So I've already mentioned Coca-Cola. They have a very strong trademark. McDonald's is another one. And what a trademark has to do to be able to be used or be enforced as a trademark is it has to be able to distinguish your company from all the others. And so if you've got a term that, if you're, so first of all, if it's generic, so there's a range of trademarks that are, and their strength. The weakest is generic, and it can't be trademarked because it can't distinguish your company from others. If you're a bricklayer and you want the trademark for bricklayer, you're not going to get it because it doesn't distinguish your company from others. It's called a generic trademark. And there's a few cases where a trademark started as a trademark and became generic. Trampoline, zipper, escalator. Those are all examples, and I understand the escalator one. And for each of these, it becomes generic when somebody challenges it. So with escalator, they had a patent, and so they had back then it was 17 years of exclusive rights to it. They had the whole market. They were making these escalators, and then their patent ran out and they got competitors. The competitors called it an escalator. And they said, no, that's our brand. We trademarked that. And so in court, they said, what do people call it? What is it? It is an escalator. They could have called it an escalator brand moving staircase. And then escalator would be a brand name, and you would recognize it as one type, and we would call them moving staircases. But because they had a new product, and trademark needs to say who, not what. It needs to say who it is. And in this case, they made the mistake of educating the public. This is what it is. So that's one of the things a trademark needs to do. And when a trademark, so you can get a trademark that's descriptive. It just describes exactly what you do. There's a trademark I've seen out there, 2 men and a truck. Very descriptive. You call them, you expect to get 2 men and a truck. They're a moving company. They've got a logo, which is unique, kind of looks like, a kid's drawing a little bit. And they won't be able to, because it's descriptive on the words, they won't be able to stop somebody that has 3 men in a truck. But they can get a trademark. And there's a couple different ways. Basically, they need to show that it has become recognized as a company. If it hasn't become recognized as a company, then it's not able to be trademarked, except there's a supplemental register. There's 2 trademark registers federally. There's the principal register and the supplemental register. The supplemental register gives you far fewer rights. And I've got a lot of clients that come to me because Amazon says you need a trademark if you want to be in our brand protection program. And if it's on the supplemental register, you don't get into that program on Amazon. So it means, so the supplemental register is kind of a holding space for somebody who's developing their trademark, and it's considered too descriptive at the time. So I mean, a very descriptive trademark is 2 all beef patties, special sauce, lettuce, cheese, pickles, onions on a sesame seed bun. They haven't even actually, that's McDonald's, by the way. They haven't used that slogan for many years, but some people, maybe you did recognize that when McDonald's, but some people still remember that. So that's one of the power of a trademark. But it also kind of had a tune, so that might have been considered unique. But it was highly descriptive if you... So,
absolutely.
So the weakest categories are generic and descriptive. Then a stronger trademark is going to be something that's suggestive. If I have a company that is helping people who have been laid off to get a new job, maybe I call it Smooth Career. It suggests that, you've had a bump in your career, but we're going to smooth it out. It doesn't exactly describe it. And it needs just a little bit of creativity for you to think and say, how does that apply? Okay, I can figure it out. And then the strongest category is going to be something that's either arbitrary or fanciful. So Kodak, they call that fanciful. It's a made up term. There is no Kodak. Apple, it is a word that we have, but when it applies to computers, and a fruit has nothing to do with computers. So it's arbitrary. There's no association between the two. And so those are the strongest trademarks out the gate. But they're also the hardest to start with marketing. Because if I have if I want to brand banana as my law firm, nobody knows
that they're
what is a banana law firm. Are you protecting fruit?
Exactly.
So you have to educate the public, and it may take a lot more marketing dollars or power to get to that brand recognition. But once you're there, if anyone comes close to you because it's arbitrary or fanciful, then it's much easier to stop them. So there's a company that is, and that's one of the dichotomies here is even though descriptive or generic trademarks sound great for marketing, if you're a bricklayer, you want to get bricklayer.com. That'd be great. But it doesn't distinguish you from other companies. And with a lot of these things, there are these exceptions or how to fit into things. And, if you're there, I can talk to you about, can we slip it in? Does the strategy make sense? A lot of times people will build up a brand without knowing these things. And then they've got a lot of goodwill in a brand, but that brand has some challenges. And it's painful to change your brand. So working with a trademark attorney early on to understand, is this brand going to work is really important. And then also avoiding infringement of others is really important. I saw a restaurant. It was part of a franchise chain, and I had, ordered takeout food from that restaurant several times. It was in my phone, and then one day I get a flyer on my porch, and at first glance it looks like that restaurant, but it's not. It has a slightly different name. It has the same kind of colors. So I'm like, something's off here. So I go to my phone and I dial that restaurant, and it's the same as this flyer. And what happened was that somebody had bought the restaurant from the current owner, and they bought it at the end of a franchise, their franchise contract, and they didn't renew it. But they didn't. They made a slight change to the name, but not enough. And they were sued and shut down within 90 days. It's just painful to watch. I ended up, asking the owner what was going on, and found out that he had moved a family member from another state to help manage it. He had basically put all his retirement or his, nest egg into buying it and getting it up and running. And all that was gone within 90 days. It's just so sad. And if so, a trademark does not have to be the exact same to be infringing. It needs to suggest an association with another company or confuse people, even if just initially confuse people. So, and the stronger the trademark, the less confusion you need to be at risk. So,
yeah. No, that makes perfect sense. That really breaks it down to, what a trademark is, how it's used, and the different areas that are involved. So that was really good. I really liked that. I think that the next thing I want to kind of get into before we get into some actionable steps is timelines and like costs, if you will, as far as like broadness, so that people who are thinking of trademarking something or getting a patent can understand what they're getting into.
Right. Okay. So we'll start with trademarks. The process is what we recommend is if someone comes to us and they've got a brand, whether or not they're using it currently, we recommend doing research first. We've got a process to do that research, and we let you know here, does it look clear? And as well as we'll let you know up front, does this look like a strong trademark? The vast majority of the time, people have already settled on a trademark before they come to me. A few times they're like, okay, this is one I think will work. Let's discuss it. And once I educate them more on trademarks, they go, okay, let's not do that one. Let me go back to the drawing board and get another one. But when I research the trademarks, I let them know, what it is, and especially what's already in the trademark office. One of the things I forgot to mention on trademarks that's pretty important is that trademarks are not based on the registration. The rights themselves, the registration strengthens it. Now, when you compare that to patents, you have no rights unless it's registered. You can't say, hey, he stole my idea. If you didn't have a contract with that person, if you don't have a patent, and they didn't break into your facility or somehow breach your security, then they're free to steal it. So you have to have a registration to have rights under patents or a contract, and then it's maybe trade secrets or an employment agreement. But with trademarks, when somebody uses a trademark, they have rights, because trademarks are about preventing consumer confusion. So if the consumers, even if it's just in one city, have already learned that, okay, there's a company or a restaurant that with this name, and it's being uniquely used in that location, they have rights before you. Now the federal registration takes that right, and even if you're still just using it in one city, it extends it to the whole nation. They actually pretend that everybody in the nation knows your brand related to the specific goods or services, products or professional services or whatever that you're offering. And so that's another thing to look out for is if somebody is using a trademark already, even if they don't have it registered, that can become a problem. And I'll talk about that a little bit more in the process. So after we do research, if we don't find any problems, we go ahead and get a trademark filed. Our normal timeline is about 6 weeks from when we start working together to doing the research and getting that trademark filed, if everything goes well. But then in the trademark office, it depends on their backlog. Their backlog has varied between the first step is for the examiner to, there's a trademark examiner assigned to it. It's an attorney in the patent office, and that attorney will do their own research and make a determination. And they, in the past, it's been as little as 3 months until they assign it to that attorney. And then they usually get to it within a couple of weeks of being assigned. Right now, it's over 8 months before they assign it. As I mentioned, Amazon, our change in economy after COVID has put a lot more people online, and that federal protection is a lot more important when you're online bumping into other companies than if you're selling out of a retail location and your market is really who can drive to your location, who can you convince to drive to your location.
Mm-hmm.
So the since COVID, they've been backlogged. It's like doubled or more the amount of applications that are being filed.
Mm-hmm.
So, and after the examiner gets it, in some cases they'll give a rejection and say, here's the reasons why it's not ready. Sometimes those are minor technical rejections. They want a few words changed. And we can just do that really easy. Other times it's we need to make legal arguments, do legal research, make sure we are good to go, and present that legal argument. One of the challenges in patent and trademark law is the person we're arguing against is the person that makes the decision.
Mm-hmm.
So an examiner gets assigned and they come up with an argument of why it's not they might say, well, it's too confusing with this other trademark.
Mm-hmm.
So if I think he's wrong or she is wrong, I have to convince them that their own first look at it is wrong.
Mm-hmm.
So I have to play nice.
Yeah.
And but present good logical arguments and good legal research. We can, if we get rejected a second time, we can appeal it,
Mm-hmm.
both the patent and trademark side, and then it goes to an appeal board. And it's sometimes they reverse the examiner. So if there is no rejection, it usually takes another 4 months after the examiner looks at it to get the registration finalized. There's first of all, there's a publication period. When they publish it, it lets the public know, hey, we think this trademark is good. Anybody can object to it. Mm-hmm. If somebody does object to it, they file and it starts a litigation type proceeding. It's a very small percentage of the cases, but if you're trying to trademark Nike or computers, nobody's using Nike for computers. Well, Nike is probably still going to have a problem with it and object to you.
Yeah.
And a really good example of that is actually Quality Inns. They own 4 or 5 brands of hotels, and they were planning to add another one called Mix Sleep Inn.
Mm-hmm.
So what is your guess of who had a problem with that?
Sleeping, I think there's a place called Sleep Inn.
No, Mix Sleep Inn. MC Sleep.
Oh, yeah.
So
I don't know.
It's McDonald's. Because McDonald's and actually I think they probably backed off on this. Like 20 years ago, they had McShoes, they had I mean, McDonald's was like doing all kinds of products, and they backed off on that. But at that time, they were just in just about every category except and McDonald's won the case because they could show that people are likely to make an association.
Mm-hmm.
And so there's a bunch of factors that go into it, but really the first thing is your gut instinct.
Mm-hmm.
I do often ask people to put the shoe on the other foot. Okay, there's this company out there. If you're this company and somebody comes out with this new name, are you going to be upset?
Mm-hmm.
And if the answer is yes, don't do it.
Yeah. Avoid the hassle.
Hard as it is, and it is not an easy process to find a name that works in a whole bunch of different ways. You got to make sure it doesn't have some meaning in another language that's bad. The Nova is an example of that. In, no va in Spanish means doesn't go. or could be interpreted that.
Mhm.
And so when they tried to sell the Nova down in Mexico, it didn't do so well, even though it was a very, sporty car.
Yeah.
Uh, so
Okay. So then let's go with patents, the timelines for that.
okay. Oh, I don't think I mentioned the costs for
Yeah.
trademarks.
Yeah.
Okay, so um, just as broad stroke, if there's no challenges, doing the research, filing, including filing fees, if you're just doing one trademark class, there are 45 different classes. There's a different class for clothing, a different class for bags. So if you're doing sports clothing and sports bags, you probably want two classes.
Hmm.
And there are a few different services classes, but a lot of different product classes.
Hmm.
So a total of 45. And there's an extra, so there's a separate filing fee in the trademark office for each class.
Hmm.
Um, and with just one class, we expect to be around or under $2,000 to for our fees and the trademark fees.
Hmm.
And you add on around $500 for per class for attorney's fees and trademark fees.
Hmm.
If it's rejected, it really depends on the type of rejection. It could be only a couple $100 or it could be a couple $1,000.
Hmm.
If there's an opposition, it starts a litigation process. And litigation means there's a phase where it's discovery. You're asking the other side to produce documents. They're asking you to produce documents. Depositions, where you're with a court reporter, you're sworn under oath, and you're answering questions. And there's this back and forth that sometimes can get very expensive. So it really depends. You could easily spend $30,000. If it's a big fight, you could spend $100,000 to fight for this trademark.
Hmm.
And so a very small percentage. And what is most common when when we end up in that situation is when somebody comes to me and says, I haven't filed a federal trademark registration. I've been using this trademark for years,
Hmm.
and somebody else started using it.
Yeah.
So we file for a trademark registration, and that somebody else says, no, I don't want you to get that. I
Hmm.
think I should get it, or neither one of us should get it. Nobody should have exclusive rights, both, but usually it's the other person says, well, here's the reason you don't have it.
Hmm.
So it goes back and forth with this fact-finding process. And it's before an appeal board that so they're considered judges, but it's a board, not a court that
Hmm.
it's before. And so kind of the worst case scenario is you're, fighting a big old fight with somebody else.
Hmm.
Uh, Whenever we introduce an adverse party, the cost goes way up.
Yeah,
The
of course.
the trademark office is not considered an adverse party. Um,
Hmm.
they're they're there to just make sure it's done right. Um, and sometimes we disagree with them, but that doesn't make them adverse. They're not advocating for a certain position,
Hmm.
just trying to get it right.
Yeah.
So that's the ranges. And if whenever somebody comes to me with that scenario, I let them know, hey, let's talk about how much you're willing to fight this.
Yeah.
Because and for some businesses, $100,000, totally worth it.
Yeah.
If you got $100 million every year of revenue riding on that brand,
Hmm.
yeah, $100,000 is a not it's not a small expense for any company, but it's doable. But if you're a startup
Yeah.
and you've barely made it into revenue or just barely profitable, $100,000 could wipe you out.
Yeah.
So,
Absolutely.
yeah.
All right. So let's talk patent real quick.
Okay. So patents, we also recommend doing research. And we go through a research process. We've got a research team that does a great job. They're very specialized in doing research. And we usually expect about 6 weeks to complete the research. And then if that comes back good, we budget time-wise 6 weeks to get the patent application prepared and filed. For a patent, the research and filing process is it varies some with how complex what it is we're patenting, but kind of around $15,000 for research and that preparation and filing. In the patent office, they are it also depends. They send it to each technology area. So some technology areas, they have a harder time finding enough people, and they hire people that are have the technical background in the technology that you're filing a patent application for. And they, for the most part, don't have law degrees. They have the technical training, and then they're trained in the law at the patent office. And the timeline is often close to 3 years, maybe 2.5 years to get all the way through the patent office. The vast majority of time, you get a rejection from the patent office, and the average is actually close to 3 rejections before you get it finally approved. And so after the patent office examines it, which might be anywhere from 1 year to 2 years or 5 years in some cases I've seen, to finally start examination. And then we have a back and forth, and we have costs for that. So we kind of, just as a broad brush, encourage people to have another $15,000 budgeted at that point to get through the patent office. Sometimes on a rare basis, we might need to do an appeal, which can add some costs. And it isn't, not all patents make it through, but when we do the research, we have a much better chance of making it through. And there are cases where we do the research and we say, we don't see that you're going to make it through the patent office. You'll get rejected and we'll probably get stuck.
Yeah.
So that's the time frame. There is a way to get on a fast track. You pay an extra fee. It's usually $2,100 extra filing fees, and then they get to your case usually within 4 months of filing.
Mm-hmm.
And then their goal is to get through 2 office actions by the end of 12 months. A lot of times we get through it in like 8 months. So if we can work closely with the patent office, sometimes we get the patent granted in 1 year on the fast track rather than 3 years.
Yeah, that's definitely beneficial, I would imagine.
Yeah.
Cool. So I think that really kind of puts a lot into perspective, and we definitely unpacked a lot. So to wrap this all up, what are like 2 first steps that they should do when they're thinking of doing a patent or a trademark? Like, based on everything we said, what are like some actionable things for them to do?
So if you think you have something that might be patentable and that would be worth filing a patent on, keep your mouth shut. Don't go telling everybody about it. The people you tell about it, make sure they've got an obligation in some kind of contract or fiduciary relationship where they have to keep it confidential. And have employment contracts. If you got an idea and you realize, you look at your company, you don't have confidentiality contracts with all your employees, well, maybe it's time to do that real quick before you start working with your team.
Mm-hmm.
If you're going to work with outside vendors, which is very common, make sure you have a confidentiality contract. Some people call them non-disclosure agreements, but some of those are very narrow and don't give you all the protection you need. So kind of an attorney can help you make sure you got a good agreement, but until you do, keep your mouth shut.
Yeah, absolutely.
And with trademark, doing that research early on is very valuable. And it's very much who used it first and who filed it. Once you file a federal trademark, they treat it as if the whole country knows about it, as long as you get the registration. So sometimes it comes down to a filing date of who's first, both in the patent office and the trademark office. But for trademarks, it's more who can prove they were actually using it to sell stuff first.
Yeah. Okay. Awesome. Well, so I really think we went through a lot there, and I definitely think that we unpacked a lot of that everybody needs to know. If you're thinking of doing a trademark or a patent, definitely reach out to Wayne. So thank you so much, Wayne. I really appreciate your time. And everybody, thank you for listening in, and we will see you tonight at the networking event at 5:30 Eastern Time.